ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ ಮರ್ತೂರು, ಸಹಯೋಗ ಕರ್ನಾಟಕ ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕಡಗಂಚಿ ಕಲಬುರಗಿ ಮತ್ತು ಕರ್ನಾಟಕ ಕಾನೂನು ಮಹಾವಿದ್ಯಾಲಯ ಹುಬ್ಬಳ್ಳಿ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿ ಡಾಕ್ಟರ್ ಮ ರಾಮಜೋಯಿಸ್ರ 94ನೇ ಹುಟ್ಟು ಹಬ್ಬದ ಆಚರಣೆಗಾಗಿ ಸರಣಿ ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮಗಳು. ನಾನು ಅಮಿತ್ ಕುಮಾರ್ ದೇಶಪಾಂಡೆ, ಕಾರ್ಯಕ್ರಮದ ಸಂಯೋಜಕರು. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರಗಳು. ಅಧ್ಯಕ್ಷರಾದ ಶ್ರೀ ಬಸವರಾಜ್ ಪಾಟೀಲ್ ಸೇಡಂ ಮತ್ತು ವಿಶ್ವಸ್ಥರಾದ ಶ್ರೀ ಮಹಾದೇವಯ್ಯ ಕರದಳ್ಳಿಯವರ ಮಾರ್ಗದರ್ಶನದಲ್ಲಿ ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ ಮರ್ತೂರು, ಕರ್ನಾಟಕ ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕಡಗಂಚಿ ಕಲಬುರಗಿ ಮತ್ತು ಕರ್ನಾಟಕ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯ ಹುಬ್ಬಳ್ಳಿ ವತಿಯಿಂದ ಉಪನ್ಯಾಸ, ವಿಚಾರ ಸಂಕಿರಣ, ಸಮ್ಮೇಳನ ಮುಂತಾದ ಕಾರ್ಯಕ್ರಮಗಳನ್ನು ಆಯೋಜಿಸುತ್ತಿರುವುದು ತಮಗೆ ತಿಳಿದಿರುವ ವಿಷಯವಾಗಿದೆ. ಪ್ರತಿ ವರ್ಷದಂತೆ ಈ ವರ್ಷವೂ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿ ಡಾಕ್ಟರ್ ಮ ರಾಮಜೋಯಿಸ್ ರವರ 94ನೇ ಹುಟ್ಟು ಹಬ್ಬವನ್ನು ಆನ್ಲೈನ್ ನಲ್ಲಿ ಆಚರಿಸುತ್ತಿದ್ದೇವೆ. ಸರಣಿ ಉಪನ್ಯಾಸಗಳ ಮಾಲಿಕೆಯಲ್ಲಿ ಮೊದಲ ಉಪನ್ಯಾಸವನ್ನು, ಎರಡನೇ ಉಪನ್ಯಾಸವನ್ನು ಇಂದು ಜುಲೈ 28, 2024 ಆಚರಿಸುತ್ತಿದ್ದೇವೆ. ನ್ಯಾಯಮೂರ್ತಿ ಡಾಕ್ಟರ್ ಮ ರಾಮಜೋಯಿಸ್ ರವರು ಸರಳ ಸಜ್ಜನಿಕೆಯ ಸಾಕಾರ ಮೂರ್ತಿ. ಸಮಾಜದಲ್ಲಿನ ಬಡವರ ಬಗ್ಗೆ ಮತ್ತು ಪರಿಶಿಷ್ಟ ಜಾತಿ ಪಂಗಡಗಳ ಬಗ್ಗೆ ಅಪಾರ ಕಾಳಜಿಯುಳ್ಳವರು. ಭಾರತೀಯ ನ್ಯಾಯಶಾಸ್ತ್ರ ಕುರಿತು ಆಳವಾದ ಅಧ್ಯಯನ ಮಾಡಿದವರು. ರಿಲಿಜನ್ ಮತ್ತು ಧರ್ಮದಲ್ಲಿನ ವ್ಯತ್ಯಾಸ ಭಾರತೀಯರಿಗೆ ಮನಗಾಣಿಸಿದರು. ಮೇರು ವ್ಯಕ್ತಿತ್ವದ ನ್ಯಾಯಮೂರ್ತಿಗಳ ವಿಚಾರಗಳನ್ನು ಸಮಾಜದ ಕಟ್ಟಕಡೆಯ ವ್ಯಕ್ತಿಗೆ ಮತ್ತು ಯುವ ಪೀಳಿಗೆಗೆ ತಲುಪಿಸುವ ಸಾಧನವನ್ನಾಗಿ ಅವರ ಜನ್ಮದಿನದ ಅರ್ಥಪೂರ್ಣ ಆಚರಣೆ ಆಯೋಜಿಸಲಾಗಿದೆ. ಸಂತೃಪ್ತ ಮತ್ತು ಸಮೃದ್ಧ ಪಾರಿವಾರಿಕ ಜೀವನ ನಡೆಸಿದವರು. ಅವರ ಜನ್ಮದ ಸಂದರ್ಭದಲ್ಲಿ ಅವರಿಗೆ ಪ್ರಿಯವಾದ ಭಾರತೀಯ ಕಾನೂನು ಶಾಸ್ತ್ರ ಜೊತೆಗೆ ಪ್ರಸ್ತುತ ಕಾನೂನು ಅಧ್ಯಯನ ಕುರಿತಂತೆ ತಜ್ಞರಿಂದ ಉಪನ್ಯಾಸಗಳನ್ನು ಏರ್ಪಡಿಸಲಾಗಿದೆ. ಇಂದಿನ ನಮ್ಮ ಕಾರ್ಯಕ್ರಮದ ಅತಿಥಿ ಉಪನ್ಯಾಸಕರನ್ನು ಅಧ್ಯಕ್ಷರನ್ನು ಪರಿಚಯ ಮಾಡಿಸಿ ಸ್ವಾಗತಿಸಲು ಡಾಕ್ಟರ್ ರೇಣುಕಾ ಗುಬ್ಬೇವಾಡ್, ಕರ್ನಾಟಕ ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕಡಗಂಚಿ ಕಲಬುರಗಿ ಅವರನ್ನು ವಿನಂತಿಸುತ್ತೇನೆ.
ಧನ್ಯವಾದಗಳು ಸರ್. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರಗಳು. Hindu law is the law of the Smritis as expounded in the Sanskrit commentaries and digest, which as modified and supplemented by the custom is administered by this country. With these words of mine, good evening to all. The Vignaneshwara Pratisthana Trust, Marturu, Kalburgi, in association with Department of Law, Central University of Karnataka, Kadganchi, Kalburgi, Department of Law, Central University of Karnataka, Kadganchi, Kalburgi, and Karnataka State Law University, Hubli, is organizing the Justice Dr. M. Ramajoy's Memorial Online Lecture Series 2024 to commemorate the 94th birth anniversary of legal luminary. Firstly, I would like to welcome the speaker of today's session, Shri S.N. Bhat, Senior Advocate, Supreme Court, New Delhi, who is enlightening us on the legal framework for civil litigation perspective. I also welcome the president of today's function, Honorable Professor Bhattu Satyanarayan Sir, Vice Chancellor of Central University of Karnataka, and it gives me a pleasure and I feel proud to say that under his dynamic leadership, the Central University of Karnataka has won the 38th rank in India today. So I welcome you, sir. I also welcome Shri Basuraj Patil Sedam, former member of the Parliament and the President, Vignaneshwara Pratisthana Trust. Welcome you, sir. I welcome Dr. C. Basuraju, sir, Vice Chancellor of Karnataka State Law University, Hubli, the principals of Kalyana Karnataka Law Colleges, teaching faculty, the deans of Central University of Karnataka and the Karnataka State Law University, and the faculty members of the respective university. I also welcome the coordinators of this lecture series, Shri Amit Kumar Deshpande, Senior Advocate and Trustee, Vignaneshwara Pratisthana Trust, and Shri S.C. Patil, Trustee, Vignaneshwara Pratisthana Trust, and Dr. Basaraj M. Kulkarni, Dean, School of Legal Jurisprudence Studies, Central University of Karnataka. I also welcome Shri Mahadevaya Karadalli, Hiriya Vishwastakaru, the personality under his guidance. This lecture series are taking their shape. I also welcome the students of law colleges and the university. I welcome one and all to this lecture series. With this welcome, now it's my pleasure to have an introduction of this eminent personality, Shri S.N. Bhat. S.N. Bhat, sir, who is an advocate, senior advocate of Supreme Court, New Delhi, hails from Dakshina Kannada, a district from in Karnataka. Sir has passed the examination of advocate on record in 1986, conducted by the Supreme Court. Sir appeared as an advocate on record before the Supreme Court in many matters such as civil, criminal, service matters, and the constitutional matters. Sir also appeared as a standing counsel for the state of Uttar Pradesh in large number of cases. Sir has been designated as senior advocate by the Supreme Court of India in December 2021 and presently working as a senior advocate in Supreme Court in New Delhi. With this brief introduction, I welcome you to this lecture series, sir. And I am also very thankful to the organizers for giving me this opportunity. Thank you.
ಧನ್ಯವಾದ ಮೇಡಮ್. ಇಂದಿನ ನಮ್ಮ ಕಾರ್ಯಕ್ರಮದ ಅತಿಥಿ ಉಪನ್ಯಾಸಕರನ್ನು ಅಧ್ಯಕ್ಷರನ್ನು ಪರಿಚಯ ಮಾಡಿಸಿದ ಡಾಕ್ಟರ್ ರೇಣುಕಾ ಗುಬ್ಬೇವಾಡ್ ಅವರಿಗೆ ಧನ್ಯವಾದಗಳು. ನಾನೆಲ್ಲರಿಗೂ ವಿನಂತಿಸುತ್ತೇನೆ, ಆನರಬಲ್ ಸ್ಪೀಕರ್ ಮತ್ತೆ ಆನರಬಲ್ ವೈಸ್ ಚಾನ್ಸಲರ್ ಮತ್ತೆ ಇನ್ನಿತರವ್ರು ಯಾರು ಮಾತಾಡಬೇಕಂತ ಬಯಸ್ತಾರೆ ಅವ್ರನ್ನ ಬಿಟ್ಟು ಬೇರೆಯವರೆಲ್ಲರೂ ತಮ್ಮ ಧ್ವನಿಯನ್ನು ಮ್ಯೂಟ್ ಮಾಡಬೇಕಂತ ವಿನಂತಿ. Please mute yourself, sir. All the others are requested to mute yourself. The Honorable Speaker and the Honorable Vice Chancellor will be available to now talk. ಇಂದಿನ
ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಲಾ ಅಂತ ಏನಿದೆ ದಯವಿಟ್ಟು ಅವ್ರು ಮ್ಯೂಟ್ ಮಾಡಬೇಕು. ಐ ರಿಕ್ವೆಸ್ಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಲಾ ಅಂತ ಏನಿದೆ ದಯವಿಟ್ಟು ಅವ್ರು ಮ್ಯೂಟ್ ಮಾಡಬೇಕು. ಥ್ಯಾಂಕ್ ಯು.
ಎಸ್ ಸರ್, ಮಾಡಿದ್ದೇವೆ. ಇಂದಿನ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಮುಖ್ಯ ಉಪನ್ಯಾಸ ನೀಡಲು ಆಗಮಿಸಿದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹಿರಿಯ ನ್ಯಾಯವಾದಿಗಳಾದ ಶ್ರೀ ಎಸ್.ಎನ್. ಭಟ್ ರವರು ತಮ್ಮ ಉಪನ್ಯಾಸ ನೀಡಬೇಕೆಂದು ವಿನಂತಿಸುತ್ತೇನೆ.
Thank you, Amit Deshpande. It's a great pleasure and honor to speak on this occasion. I remember having associated myself with Justice Ramajos. He was a mentor for me, and I had assisted and appeared along with him in a large number of cases. His personality was an inspiring one. He came from a very humble background, and his hard work, his commitment, and his intellect took him to great heights. But he would be very humble and very down to earth in his approach to even the junior most member of the bar when he was practicing after his retirement as Chief Justice of Punjab and Haryana High Court. He came to Supreme Court and appeared in matters where I had occasion to associate myself with him, as I was saying. And he virtually held my hand and mentored me. Therefore, This is a great honor and privilege for me to present my views on the subject, today's subject. I would be failing in my duty if I don't pay my respectful homage to the memory of Justice Ramajoyce, as Mr. Amit Kumar was saying. Yesterday was his birthday, so his inspiring figure and his memory should guide us on in every one of our endeavor, not merely in the legal field, but in every activity. Because he was a great patriot, apart from the fact that he was a great legal luminary, as Amit was saying. He was a great lawyer, a great judge, and a legal luminary. Added to that, his concern for the downtrodden and the welfare of the lowest of the low, and his commitment to the ideals of justice were unparalleled. Therefore, his memory should, as I was saying, guide us on in every one of our activities. With this homage to his memory, with his blessings, from wherever he is, I begin to put my thoughts on the subject of the day. When Amit asked me to speak on any subject of my choice, I had little hesitancy to speak about subjects which are the currency of the day. In the sense, today people are talking about constitutional values and the new set of amendments of the new set of criminal laws that have come into force. They are the topics of the day. We
So
haven't
we
been.
would also appreciate if you also mix a little bit of Kannada, if possible, Telugu and English.
I suppose
ಕನ್ನಡದಲ್ಲಿ ಮಾತಾಡಿದ್ರೆ ಎಲ್ರಿಗೂ ಒಂದ್ ಸ್ವಲ್ಪ ಅನುಕೂಲ ಆಗುತ್ತೆ ನಮಗೆ.
ನನ್ನ ಥಾಟ್ಸ್ ಅನ್ನ ಕನ್ನಡ ಮಾತಾಡ್ಲಿಕ್ಕೆ ಬರುತ್ತೆ, ಆದ್ರೆ ನನ್ನ ಥಾಟ್ಸ್ ಅನ್ನ ಕನ್ನಡದಲ್ಲಿ ಐ ಡೋಂಟ್ ನೋ ವೆದರ್ ಐ ವಿಲ್ ಬಿ ಏಬಲ್ ಟು ರಿಯಲಿ ಕನ್ವೆ, ಬಿಕಾಸ್ ಈಗ ಕನ್ನಡದ ಟಚ್ ಸ್ವಲ್ಪ ಕಡಿಮೆ ಆಗಿದೆ after having settled down here in Delhi for the last 40 years or so. So I would beg your pardon if I continue speaking in English, I suppose.
Yes.
As I said, I chose this subject, legal framework for the civil litigation, a perspective, because I wanted to put my perspective. This is only my perspective, and I don't know whether it will go down well with people who are in the field of legal practice, who are accustomed to what has been given down to us over the ages by way of legal framework for disposing civil matters and dispensing civil justice in our country. As this is a topic which is, according to me, a little neglected in our public discourse. People speak about, because it is a fashionable day to talk about constitutional values and to reaffirm the constitutional values, as well as to bring about changes in other fields of legal framework. But except for occasional voices that we hear here and there once in a while with regard to the tendency and the tardiness in disposal of civil matters, hardly there is an occasion for thinking about what we can possibly do about the structural deficiencies that are there in the legal framework which govern our civil litigation. So I thought that I have thought about the matter for some while, and I thought I would, on this occasion, it would be a befitting homage to Justice Ramajoyce, whom I revere as one of my dearest seniors. Uh, Therefore, I am thankful to all of you for having given me this opportunity. As I was saying, civil litigation is one of the main litigation that occupy the court dockets in our country. I read somewhere that there are about 5 crore pending matters in all the courts put together in India. Now, whenever a matter in a suit or a litigation starts with respect to any issue, whether it be property or with regard to commercial dispute or with regard to monetary dispute, whichever way a dispute is taken up in court by a litigant, it has its repercussion on the economy, because a dispute has a kind of a spoke in the free running of the economy. Once the matter gets into court litigation, unless it is disposed of quickly, the uncertainties of the court litigation puts a question mark on the title of the person in the property involved, or with regard to the entitlement of the party with regard to the money in dispute. And therefore, the free functioning of the economy generally gets impeded. Our Prime Minister has put a goal of making India a fully developed country by 2047, the 100th year of our independence. Now, to make our economy a fully developed one, I suppose a judicial system which is fully efficient and modern, with a modern framework in tune with the present day economical requirements, which is a very fast moving one, is very essential. Therefore, for disposal of cases speedily with an appropriate framework for that is one of the essentials for developing the economy, in my view. And I suppose every expert with regard to on this subject would agree with that proposition. There would not be any dispute with regard to that. Now, the question that arises is, have we been able to, with the present existing framework, legal framework for civil litigation, have we been able to achieve it? It would not really require much of research or discussion to say that the answer would be an emphatic no. We haven't been able to do that. The abysmally slow rate of disposal of cases, non-pendency of cases, has really sort of given birth to a coinage which is in popular parlance come to be known as Tariq pe Tariq, Tariq pe Tariq. This kind of image, this kind of impression about our judicial system has to change. If it is to change, what can we possibly do to bring about the change? That is a moot question that we have to pose ourselves. Can we bring about any structural changes in the system? Structural changes in the legal framework? That is what I was wondering. Because we have to make some kind of a stock taking at this juncture. I believe that every individual, every organization, or every society should make this kind of periodic stock change taking to see whether there is any corrective measures that require to be taken, whether any changes have to be made in the way we deal with our issues. In this regard, I have a couple of broad thoughts with regard to the civil litigation that we are dealing with. As you're all aware, under our system, the basic course for dealing with civil litigation is the civil courts. Every state has its structure of civil courts, with the junior most or the lowest grade being the civil judge, the junior division. I suppose in Karnataka it is civil judge, junior division, then civil judge, senior division, the district judge. And ultimately, the High Court as this first appellate or second appellate, as the case may be, depending upon the pecuniary jurisdiction of the matters, would be dealing with this civil appeals. Under Section 9 of the Code of Civil Procedure, civil courts have every jurisdiction to deal with the almost any conceivable civil dispute. That is our jurisprudence, that is our legal system. But over the years, in order to, in an attempt, so to say, to bring an expedite disposal of certain specific kind of cases, the jurisdiction of civil courts were taken away with regard to quite a few subjects, and special tribunals were created for the purpose of disposal of cases, giving exclusive jurisdiction to these tribunals. Now we have a situation where we have plethora of tribunals dealing with variety of subjects. These tribunals were created with the fond hope that since they are manned by experts in the particular field and they are exclusively dedicated for dealing with those particular subjects only, they would be in a position to take up and dispose of cases expeditiously, and the burden of civil courts also would be reduced. But I feel that is at least my personal opinion and my perspective. That is the reason I said that I wanted to put this perspective with regard to our civil legal framework before you people. It is only a food for thought. One may agree with that or one may not agree with that. I feel that this tribunalization by hiving off jurisdiction from civil courts, which were originally the subject matter of the jurisdiction of the civil court, to specially created tribunals have not really served the purpose. Now we have large number of tribunals, as I have just now mentioned. You have tribunals, debt recovery tribunal for dealing with the recovery of bank debts, etc., etc. You have consumer commission for the under Consumer Protection Act to deal with consumer disputes. You have competition commission specializing in subjects concerning monopolies, etc., etc. You have service tribunals like the Central Administrative Tribunal for central government servants disputes, state administrative tribunals in almost every state. And there also there are specialized tribunals with regard to armed forces, tax tribunals of different kind, and then you have other tribunals with regard to various other subjects. But tribunals, creation of these tribunals had not really achieved the purpose for which they have been created. Added to that, the tribunals have also spawned a new problem, which give rise to another difficulty. Instead of expediting the disposal of cases, this exclusive jurisdiction conferred on the tribunals, taking it away from civil courts, has given rise to disputes with regard to the jurisdiction of the tribunal. In every second case, the moment a cause is put before the tribunal, a litigant comes before a tribunal with regard to a specific subject, be consumer dispute. Let us take, for example, one of the stock contentions taken before the tribunal is with regard to the jurisdiction of the tribunal. That is a convenient lever used by the opposite party, the defendant, in order to delay the matter. And unfortunately, that has resulted in a kind of a jurisprudence of its own, with dealing with the questions of jurisdiction. I was just now trying to find out what is the case with regard to, as I was talking about the Consumer Protection Act and questions that arise in those consumer cases. I was trying to find out the number of cases and number of issues that arise with regard to jurisdiction of the tribunal in the consumer courts. I found that there are at least 100 to 150 cases of the Supreme Court, reported cases of the Supreme Court, dealing with the jurisdiction of consumer courts alone. That means that matters which ought to have been decided by the consumer court on merits, which ought to have been decided without reference to, if it were before the civil court, supposing it was the case was to be decided before the civil court, as it used to be the dispensation, the regime earlier, there would not have been any difficulty with regard to jurisdiction. Supposing the man, this Consumer Protection Act was not enacted, he would have straightaway gone to civil court, and civil court would have decided the case. The question of jurisdiction would not have arisen. But since a special tribunal was created, an area of dispute naturally came up and naturally was taken up by lawyers with regard to the jurisdiction. And as I was saying, the question of jurisdiction of the tribunal itself becomes a contested issue right from the lowest rung up to the Supreme Court. And ultimately, in some of the cases, the Supreme Court, after the decision having come up the ladder to the Supreme Court, after 15 years, in some cases 20 years, would decide, even though there was merit in the claim made by the complainant, that the consumer court unfortunately did not have them. So the man goes back that again, driven to some other forum, either civil court or some other forum. This kind of difficulties faced by litigant. The litigant is not bothered about whether the tribunals has jurisdiction or civil court has jurisdiction. He is essentially interested in his cause or his dispute being decided on merit. He wants relief because the state is called upon, state as a provider of justice is called upon to give justice to the and wrong. If he comes to a court or a tribunal created by the state, he expects that he be given speedy justice. He does not want or he is not interested in the final issues of jurisdiction and related questions of jurisprudence, which may be good for legal learning. In these circumstances, it is my firm belief that it is time to do away with the tribunalization. It's a very highly technical and technical expertise is required. In other cases of ordinary civil disputes, including disputes of the natures that I was mentioning, it is time to do away with these kind of tribunals and confer again jurisdiction on civil courts. Civil courts earlier used to have this kind of jurisdiction, and the creation of tribunals has only added to the problem and has not in any way improved the situation. The litigant would be happy to have one window solution where he could go, put in his case, engage a lawyer without being bothered about whether the court has jurisdiction about it, whether after having won the case on merits before the lower court, ultimately he would be haunted by the issue of jurisdiction at the higher courts. Because in our legal system, as you would be aware, that subject matter jurisdiction, where a court has jurisdiction with regard to the subject it was dealing with, can be taken up even at the appeal stage in the highest of courts, even in the Supreme Court. And the Supreme Court has held that even at the time of execution proceedings, after having conclusively won on merits with regard to a claim, when the man goes in for executing the deed, the opposite party could very well set up that the court which passed order of the decree did not have jurisdiction. In which event, the man having struggled through the court systems for years together would be back to square one. Scheme of thing. It is the duty of the state as justice provider to have a justice delivery system under one umbrella. If it is possible for a higher, like the High Court, to entertain all manner of disputes, the the DP can go
Sir, some buffering in your work probably, sir.
a window, so to say, to a premises. Excuse me.
Sir, your network seems to be weak, sir. Please come to a. Yes, sir, you are now audible. Sir. There
Am
was
I
some
audible
buffering
now?
in between. Please continue.
Yeah. So it is a duty in, as I was saying, of the state to provide for justice delivery system under one umbrella. One umbrella, I mean that man doesn't have to bother about uh, of the, be it lower court or higher court. He has to put in his and he has to get his justice from that court. Within the there may be divisions like you have divisions of commercial court, you have divisions for deciding consumer disputes, you have divisions for deciding service disputes, you have divisions for deciding any other. He should not be bothered with regard to the position of the jurisdiction of the court because the court keeps on point. The court is the creature of the state which is instead of this right to that from the, the state. That is one of the basic duties of the state. I can cite one example. In my view, it is a very sad state of affairs and resulted in travesty of justice when I was talking about this problem of jurisdiction by creation of specialized tribunal. In 2009, after the consumer courts were created, consumer commissions were created under the consumer protection. There are large number of complaints filed before consumer commissions and consumer court with regard to efficiency in service by telecom service providers, telephone companies, higher billing, excessive or non-providing of good service, disconnection, unauthorized connections, etc. They were being entertained and disposed of. In one of the cases, after having one before the case below, after long years of struggle, the question of jurisdiction of consumer forum with regard to relating to telecom services was raised. In 2009, in a reported decision, that quoted a perfect of telecom bench of the Supreme Court. It said there that since the was a provision for appointment of arbitrator by the government for resolving disputes arising under that. The Consumer Forum and Consumer Protection Act to entertain the dispute. And the Supreme Court, even though the party won in on jurisdiction, decision was non-exist. Now, this one decision and ending in district state consumer commission for years, and even in national consumer defense for years to be without deciding merits only on the ground that though it has been pending for years together. Since the Supreme Court has taken, there was no jurisdiction forum. How to go? The dispute at first, if they have just the dispute before the government under the process of the Telegraph Act. And as fate would have it, this very decision of Supreme Court in 2009 886 481, which I was just now referring, came to be overruled in the year 2022. That decision which held that the consumer fora under the Consumer Protection Act did not have jurisdiction is the wrong decision. And consumer under the Consumer Protection Act very well had jurisdiction. That decision in 2022 6 reverses a decision of 2000 and in between or that the consumer could not exercise the jurisdiction. What is driving it is kind of artificial, my view, artificial division of jurisdiction.
Sir, your network seems to have, sir, you seem to have been disconnected, or the network is very low. Sir, you are not audible, sir. Sir, you are not audible at all now.
Can you hear me?
Yes, sir. Can you please come little closer to the mic and be little louder, sir? The network is very low, sir, wherever you are. Also to remind that it is 7:24.
Hear me now?
Yeah,
Am I audible now?
you are audible, sir.
Yeah.
Yes.
A
Therefore,
little louder, sir. And also
Yeah.
we are at 7:24 now, sir.
yeah, I will finish in 5 minutes. So that is one aspect of the matter. It may sound a little drastic or radical, but I am of the firm view that it is time that we reverse the process. Another aspect of the matter that I wanted to highlight was with regard to the court and the difficulty that we entail with by in procedure code. I will only, because of the positive, only deal with one particular aspect. That is that we have a provision for, after having instituted a suit and having process of trial and gotten a decree from the court on merits, the litigant has to start what we call the execution proceedings. A complete order deals with the issue of execution. A very learned senior advocate, when I was a young lawyer, was wondering and was taking the requirement of a party who has won the case on merits and has a decree in his favor, again asking for execution of the case by approaching the court all over again. He put it to me pitifully, why would a litigant go to a court if he doesn't want to get relief? If he has gone to court, that means that he wanted relief. Once he has been given a decree by the court, it was the duty of the court to see to it that decree is fully satisfied. He doesn't have to again go begging to the court asking for execution of the. According to him, the requirement of seeking execution of the court is, is a travesty of justice delivery system. I cannot agree with him more, because if you go to court, pay court fee, get a civil suit decided, get a decree on merits, and then again you have to do the exercise all over again to really get the fruits of your is something which is not palatable to an ordinary litigant. It is high time that we really think about this requirement. It may, I may, those who are interested in this, only buttress my argument by reference to a decision of the Supreme Court, where Supreme Court itself, Justice Ravindran, commented on this particular aspect of the matter. He was dealing with a partition suit, and he was dealing with the concept of preliminary decree and final decree in that case. But incidentally, while delivering the judgment, he commented on execution and the difficulties encountered by the parties in execution proceedings. I would like to read a passage of that very interesting comment made by the Supreme Court. It is reported in 2009 9 SCC 689. The court had, I will take only 5 minutes to read the relevant passages. At paragraph 24, the court says, a litigant coming to court seeking relief is not interested in receiving a paper decree that succeeds in establishing his case. What he wants is relief. If it is a suit for money, he wants the money. If it is a suit for property, he wants the property. He naturally wonders why, when he files a suit for recovery of money, he should first engage a lawyer and obtain a decree, and then again engage a lawyer and execute the decree. Similarly, when he files a suit for partition, he wonders why he has to first secure a preliminary decree, then file an application and obtain a final decree, and then file an execution to get the actual relief. The commonsensical query is, why not a continuous process? The litigant is perplexed as to why, when a money decree is passed, the court does not fix the date for payment, and if it is not paid, proceed with execution. When a preliminary decree is passed in a partition suit, why the court does not forthwith fix a date for appointment of a commissioner for division and make a final decree and deliver actual possession of his separated share? Why is it necessary for him to remind the court and approach the court at different stages? Because of the artificial division of the suits into preliminary decree proceedings, final decree proceedings, and execution proceedings, many trial judges tend to believe that adjudication of the right being the judicial function, they should concentrate on that part. Consequently, adequate importance is not given to the final decree proceedings and execution proceedings, which are considered to be ministerial functions. The focus is on disposing of cases rather than ensuring that the litigant gets the relief. But the focus should not only be on early disposal of cases, but also on early and easy securement of relief, for which the party approaches the court. Even among lawyers, the importance is given only to securing of a decree, not securing of relief. Many lawyers handle suits only till preliminary decree is made, then hand it over to their juniors to conduct the final decree proceedings, and then give it to their clerks for conducting the execution proceedings. Many a time, party exhausts his finances and energy by the time he secures preliminary decree and has neither the capacity nor the energy to pursue the matter to get the final decree. As a consequence, we have found cases where a suit is decreed or a preliminary decree is granted within a year or two. The final decree proceedings and execution takes decades for completion. This is an area which contributes to considerable delay and consequential loss of credibility of the judicial civil justice system. Courts and lawyers should give as much importance to final decree proceedings and execution as they give to the main suits. In the present system, when the preliminary decree for partition is marked, there is no guarantee that the plaintiff will see the fruits of the decree. The overall observation by TV counsel is that the difficulties of litigant begins when he obtains a decree. It is necessary to remember that the success in a suit is nothing to a party unless he gets the relief. Therefore, to be really efficient, the scheme of the court should enable the party not only to get a decree quickly, but also to get relief quickly. This requires a conceptual change regarding civil litigation, so that the emphasis is not only on disposal of suits, but also on securing relief to the litigant. We hope that the Law Commission and Parliament will bestow their attention to this issue and make appropriate recommendations and amendments so that the suit will be a continuous process from the stage of its initiation to the stage of securing actual relief. The present system involving a proceeding for declaration of right, a separate proceeding for quantification of ascertainment of relief, and another separate proceeding for enforcement of the decree to secure relief is outmoded, unsuited for present requirement. If there is a practice of assigning separate numbers for final decree proceeding, that should be avoided. Issuing fresh notice to the defendant at the stage should also be avoided. The Code of Civil Procedure should provide for a continuous and seamless process from the stage of filing suit to the stage of getting relief. Now, this decision of 2009 vintage, now we are almost 15 years down the line. Unfortunately, lawmakers have not really bestowed any attention to this, even though Supreme Court made a strong pitch and strong recommendation in this connection. I hope people would put your thoughts in and start a kind of a discussion on this issue with regard to the legal structure that we have. I have only highlighted two aspects which came to my mind readily. There are a number of issues which we devil our system, civil litigations in particular. Those who are interested, I would recommend to have a look at what classic analysis made by a senior advocate of very high standing of Delhi High Court, Mr. Mohan, in a book called Justice, Courts and Debates. It was published in the year 2009. You may refer to do that two-volume text. That will be very beneficial for people who are dealing with courts and who are working in the system. With these words, I again thank you very much for, I'm sorry for overshooting time. It was allotted to me. This Monday told me that 35 minutes. I suppose because of the subject that was involved, I overshot it a few minutes. I'm thankful again to you people for a patient. Wish you all a very good evening. Very
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಇಂದಿನ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಮುಖ್ಯ ಉಪನ್ಯಾಸ ನೀಡಲು ನೀಡಿದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹಿರಿಯ ನ್ಯಾಯವಾದಿಗಳಾದ ಶ್ರೀ ಎಸ್.ಎನ್. ಭಟ್ ರವರಿಗೆ ಧನ್ಯವಾದಗಳು. ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕರ್ನಾಟಕ ಕಡಗಂಚಿ ಕಲಬುರಗಿ ಮಾನ್ಯ ಕುಲಪತಿಗಳಾದ ಶ್ರೀ ಭಟ್ಟು ಸತ್ಯನಾರಾಯಣ ರವರನ್ನು ಅಧ್ಯಕ್ಷೀಯ ಭಾಷಣ ನೀಡಬೇಕೆಂದು ವಿನಂತಿಸುತ್ತೇನೆ. ಶ್ರೀ ಭಟ್ಟು ಸತ್ಯನಾರಾಯಣ, ಆನರಬಲ್ ವೈಸ್ ಚಾನ್ಸಲರ್.
Sri S.N. Bhattji, the Senior Advocate, Supreme Court. Professor Basoras, the Vice Chancellor, Law University. Sri Basoras, is it audible?
Yes, sir.
Yes,
It's
sir,
audible.
it is audible.
It is audible.
Sri Basoras Patil Sedamji, the former Rajya Sabha member, so the chairman of the Vijnana, the Pradhisthana Trust. Sri Mahadevaya ji, Basaras Kupakari ji, Sri Deshpande ji, and other invitees and participants and the students. So I'm not a legal person, but when I am going through the Sri S.N. Bhattji is a lecture, and he has covered most of the things. Now this topic, it is a very much essential, that is legal framework for civil litigation, a perspective. Now this is in this Vijnana, that is Pradhisthana Trust, which has taken this very good initiative, where in the memory of Dr. M. Rama Joyce memorial lecture, that is, I think, the 94th birthday of the Rama Joyce birthday, who is instrumental in establishment of this Vijnaneshwara Pradhisthana Trust. And when we discuss about the civil litigations and the problems, so for this, particularly when we are implementing this by particularly in the Hindu laws, whether this is applicable to other laws or not, but this Mitakshari, which was written by the Vijnaneshwara under Salukya kingdom, that is King the Vikramaditya VI, that is written here only in the area of Kalaburgi. And that is the Rama Joyce has taken an initiation to bring again glory to this area, and that's why this Vijnaneshwara Pratisthana Trust was formed. And Mahadevaya is taking a lot of interest in this one for developing and organizing this type of lectures, including to celebrate the birth anniversary of Ramajoy ji. And really, this is helping particularly the law students and advocates of this region, because now the Mitakshara, where it is the foundation for the Hindu laws, which is very essential for effective implementation. And if this region people don't go through thoroughly, and who will know about this one? Hindu laws means Mitakshari. So everyone should be perfect in this one. And if you go to the Mitakshari, there even the equal property right to the daughters also given by the Mitakshari. So that is the government of India is implemented this from 2005 itself through Act. So that is before that there is no property right to the daughters. Only whatever the properties of the parents are left over only belong to the sons. Though this Vijnaneshwara is proposed and mentioned in the Mitakshara, which was implemented way back in the 11th and 12th century. So that is our legal system. Now again, in the modern, after the constitution, after this implementation of Hindu laws, after 60 years, only we implemented such a law, which was originally proposed by the Vijnaneshwara, which was found in this Mitakshara. Now the now civil litigations are every day they are going to increase and increasing, and people are also not aware how to do, what to do, and it is a time to make awareness about this, because many people are suffering due to the civil issues. If people are aware, definitely they approach the courts for settlement instead of suffering themselves. And it is the law students and particularly law fraternity, they should bring awareness among the people about the laws which are useful to them. If any problem comes, how to resolve, and what to the mode of implementation, where to go. These the legal fraternity should make some awareness programs among citizens. If you compare to the even 10 years back or 20 years back, now there's a lot of awareness among the legal system. That's why people are nowadays they are moving, and still we need more awareness programs, particularly villages, rural areas where they are not aware. They are suffering with many issues due to the litigations. They are not able to resolve, and they do not know to whom, where to approach and whom to approach. So these are the things we should also take up this among the people to make them aware and try to resolve that issues. So nowadays it is very important. So definitely whatever the now SN Bhatji has delivered, that will definitely help particularly the law students and advocates. And for this Vijnaneshwara Pratisthana Trust is also making a lot of efforts to aware to make aware about the laws. So from our central state of Karnataka, definitely will always associate with the Vijnana Pratisthana Trust, and definitely with this our students, particularly LLM students, will benefit out of this one. And I expect some many more lectures should be organized by the Vijnaneshwara Pratisthana Trust that will be useful. And finally, this Rama Joyce who has contributed a lot for this region or for this particularly for bringing this Mitakshara into limelight. In the name of Vijnaneshwara Pratishtha Trust, and definitely this will go in long way. This will be, this is, with this, I thank the organizers for giving the opportunity. Thanks. Thank you.
ಕಾರ್ಯಕ್ರಮದ ಅಧ್ಯಕ್ಷ ಸ್ಥಾನ ಅಲಂಕರಿಸಿದ ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕರ್ನಾಟಕ ಕಡಗಂಚಿ ಕಲಬುರಗಿ ಮಾನ್ಯ ಕುಲಪತಿಗಳಾದ ಶ್ರೀ ಭಟ್ಟು ಸತ್ಯನಾರಾಯಣ ರವರಿಗೆ ತುಂಬು ಹೃದಯದ ಅಭಿನಂದನೆಗಳು. ಇಲ್ಲಿ ಒಬ್ರಿಬ್ರು ಯಾರೋ ಕೈ ಎತ್ತಿದ್ದಾರೆ. ಏನಾದ್ರೂ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳೋದಿದೆಯೋ ಅಥವಾ ತಪ್ಪಾಗಿ ಎತ್ತಿದ್ದಾರೆ ಗೊತ್ತಿಲ್ಲ. ಏನಾದ್ರೂ ಹೇಳೋದಿದ್ರೆ ತಾವು ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡು ನಮ್ಮ ಅನಿಸಿಕೆಗಳನ್ನು ಹೇಳ್ಬಹುದು, ಅಥವಾ ಏನ್ ಪ್ರಶ್ನೆ ಇದ್ರೆ ಸ್ಪೀಕರ್ ಏನೋ ಪ್ರಶ್ನೆ ಇದ್ರೆ ತಾವು ಕೇಳಬಹುದು.
Sir, I'm Raghunathan. Mr. S.N. Bhat, it was very lively talk. Thank you so much for raising the issue about the litigants being asked to walk through a long mile to get their justice. My point is, in the case of tribunals like income tax, company law and all, I think we feel that tribunal systems seem to be working fairly. Your comment, sir.
No, I do not say that every tribunal has been a failure. My point is only this much. See, instead of creating tribunals, you have it under one umbrella. That is all. You may provide for ultimately what is the objective? Objective is twofold. One is speedy justice. Second is to have people of that particular expertise within to deal with those particular subjects.
Yeah.
That you can do even without creation of tribunals. Under one particular system, you
Yeah.
can very well provide for benches. Benches dealing with, say, tax matters.
Yeah.
I'm not talking about it. In that particular field.
Yeah.
You don't have to make it
Yeah,
a special
specialized.
enactment.
Yeah.
That at least this particular, I was only dealing with the jurisdictional issue that arises because of the
True,
creation of
true.
specialized bodies.
Yeah.
You would see there are thousands of judgments of the Supreme Court which deal with exclusively the question of jurisdiction
Yes.
by by expounding fine legal concepts of jurisdiction.
Yeah.
And this issue would haunt the litigant once you
Yeah.
have separate entities of this kind. If
Yeah.
you do not have that, because you may have, it is very fine to have very great legal learning, with regard to issues of jurisdiction, etc., etc. But the point is, the ordinary litigant, be it a civil litigant or a taxation litigant or whoever, he is not, his only single goal is to get a speedy justice.
Yeah.
And
Relief.
this is his legitimate right under, because the welfare state, as a welfare state, it is even under olden
Yes.
times, when king
Yes.
used to rule, it was one of the bounden duties of the king to give justice. Well, if it is the duty of the king in the welfare state, it is all the more so to give justice and to take it to the doorsteps of the consumer of justice.
Yeah. Yeah.
That is my point.
Yes.
That is all that I said. Nothing more than that.
No, thank you. I think that's a very fair point, sir. Probably we may have to reduce the number of tribunals and focus on where there is large
You
number of.
have any number of people with
Yes.
expertise within that system.
Yes. Yes.
Create benches.
Yes.
If
That's
you
true.
can have benches in the High Court, dealing
Yes.
with tax matters, dealing with, when you go to the High Court, you don't bother about jurisdiction.
Yes.
You are
Yeah.
well aware, I'm 100% sure that the High Court has jurisdiction to deal with all manner of cases.
Yes. Yes.
If that is the position, why not civil courts or courts of a lower jurisdiction, where you
Yeah.
can have people of expertise,
Yes.
create benches there.
Yes. In fact, that will make the access to the justice also easy. Tribunals are mostly in
Yes.
metros. Yeah,
Yes,
that's,
yes.
I think
That is
that's a
my
very,
point.
yes,
You may,
yes.
you may tweak it this way, that way with final, there is a broad point that I was trying to make.
Yes. That you are able to give access to justice to people who are in the districts also, who are not in the metros.
Yes.
Yeah.
That is
Fair point, sir.
yeah,
Very
and
fair
you may,
point. Concede that.
this is the,
Senior
this is the
counsel
broad,
concede that. Concede
this is
this
the,
point.
I was only because the details will have to be fleshed out and
Yes.
worked out by
True.
better and brighter minds than mine. I don't
Yes.
say that I can do it. Few
Yeah.
people with the better and brighter minds would be able to do that.
True.
That is a
Yeah, it's a
conceptual thing.
conceptual issue.
Yeah.
Basically, it's a conceptual issue.
Yes.
Thank
ಧನ್ಯವಾದ
you. Thank you, thank you, counsel. Very, good perspective from that I could get you. Thank you.
That is only
Thank you.
my
ಧನ್ಯವಾದ.
perspective,
Thank you.
That's it. Okay. Thank you. Thank you.
ಧನ್ಯವಾದ ಸರ್. ಥ್ಯಾಂಕ್ಸ್ ಲಾಟ್ ಫಾರ್ ದಿಸ್ ಕ್ವೆಶನ್ ಅಂಡ್ ದಿ ಆನ್ಸರ್ ಸರ್. ನಾವೀಗ ಮುಂದಿನ ಘಟ್ಟಕ್ಕೆ ಹೋಗ್ಬೇಕಾ ಏನು?
ಗುಪ್ತಲಿಂಗ್ ಅನ್ನೋರು ಒಬ್ರು ಹ್ಯಾಂಡ್ ರೈಸ್ ಮಾಡಿದ್ರು ಸರ್. ಗುಪ್ತಲಿಂಗ್ ಸರ್ ಅನ್ನೋರು, ಅವ್ರಿಗೆ ಏನಾದ್ರು ಕ್ವಶನ್ ಇದೆ? ಗುಪ್ತಲಿಂಗ್ ಪಾಟೀಲ್
ಸರ್, ಗುಪ್ತಲಿಂಗ್ ಪಾಟೀಲ್ ಅವರು.
ಗುಪ್ತಲಿಂಗ್ ಪಾಟೀಲ್ ಸರ್, ಏನಾದ್ರು ಪ್ರಶ್ನೆ ಇದೆಯಾ?
ಸರ್ ಏನಿಲ್ರಿ ಸರ್, ಕರೆಕ್ಟ್ ಅದನ್ನೆಲ್ಲ ಓಕೆ ಕೇಳಿದ್ರಿ ಸರ್, ಚೆನ್ನಾಗೈತೆ ಸರ್.
ಸರ್, ಗುಪ್ತಲಿಂಗ್ ಪಾಟೀಲ್ ಅವರು ಗುಲ್ಬರ್ಗ ವಕೀಲರ ಸಂಘ ಕಲಬುರ್ಗಿ ಅದರ ಮಾನ್ಯ ಪ್ರೆಸಿಡೆಂಟ್ ಅವರಿದ್ದಾರೆ. ಅವರು ತಮ್ಮ ಸಮಯವನ್ನು ತೆಗೆದುಕೊಂಡು ಇವತ್ತು ಇಲ್ಲಿ ಉಪಸ್ಥಿತರಿದ್ದಾರೆ. ಧನ್ಯವಾದಗಳು ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಸರ್, ಈಗ ನಾವು ಮುಂದಿನ ಘಟ್ಟಕ್ಕೆ ಹೋಗೋಣ ಸರ್. ಪಾಟೀಲ್ರೆ, ಎಸ್ ಸಿ ಪಾಟೀಲ್ರೆ, ವಂದನಾರ್ಪಣೆಗಾಗಿ ಶ್ರೀ ಎಸ್ ಸಿ ಪಾಟೀಲ್ ವಿಶ್ವಸ್ತರನ್ನು ಆಮಂತ್ರಿಸುತ್ತೇನೆ. ಪಾಟೀಲ್ ಸರ್.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಕೊನೆಯ ಘಟ್ಟ ಇದು, ವಂದನಾರ್ಪಣೆ. ನಾನು ಎಸ್ ಸಿ ಪಾಟೀಲ್, ವಿಶ್ವಸ್ತ ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ ಟ್ರಸ್ಟ್ ಮರ್ತೂರು. ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ ಮರ್ತೂರು ಕರ್ನಾಟಕ ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕಡಗಂಚಿ ಕಲಬುರಗಿ ಮತ್ತು ಕರ್ನಾಟಕ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯದ ವತಿಯಿಂದ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿ ಡಾಕ್ಟರ್ ಮ ರಾಮಜೋಯಿಸ್ರವರ 94ನೇ ಹುಟ್ಟು ಹಬ್ಬವನ್ನು ಆನ್ಲೈನ್ ನಲ್ಲಿ ಸರಣಿ ಉಪನ್ಯಾಸಗಳ ಮಾಲಿಕೆಯಲ್ಲಿ ಮೊದಲನೇ ದಿನದ ಉಪನ್ಯಾಸ ನೀಡಿದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹಿರಿಯ ನ್ಯಾಯವಾದಿಗಳಾದ ಶ್ರೀ ಎಸ್ ಭಟ್ ರವರಿಗೆ ಧನ್ಯವಾದಗಳು. ಮತ್ತು ಕಾರ್ಯಕ್ರಮದ ಅಧ್ಯಕ್ಷ ಸ್ಥಾನ ಅಲಂಕರಿಸಿದ ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕರ್ನಾಟಕ ಕಡಗಂಚಿ ಕಲಬುರಗಿ ಮಾನ್ಯ ಕುಲಪತಿಗಳಾದ ಶ್ರೀ ಬಿಟ್ಟು ಸತ್ಯನಾರಾಯಣ ರವರಿಗೆ ತುಂಬು ಹೃದಯದ ಅಭಿನಂದನೆಗಳು. ಕರ್ನಾಟಕ ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕಡಗಂಚಿ ಕಲಬುರಗಿ ಮತ್ತು ಕರ್ನಾಟಕ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯ ಮಾನ್ಯ ಕುಲಪತಿಗಳವರಿಗೆ, ಡೀನ್ ರಾದ ಶ್ರೀ ಬಸವರಾಜ್ ಕುಬಕಡ್ಡಿ ಅವರಿಗೂ, ಉಪನ್ಯಾಸಕರಿಗೂ ಹಾಗೂ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಧನ್ಯವಾದಗಳು. ಅನ್ಯಾನ್ಯ ವಿಶ್ವವಿದ್ಯಾಲಯಗಳ ಮಾನ್ಯ ಉಪಕುಲಪತಿಗಳವರಿಗೆ, ವಿಶ್ವವಿದ್ಯಾಲಯಗಳ ಅಂತರ್ಗತ ಬರುವ ಕಾನೂನು ಮಹಾವಿದ್ಯಾಲಯಗಳ ಮತ್ತು ಅನ್ಯಾನ್ಯ ಮಹಾವಿದ್ಯಾಲಯಗಳ ಪ್ರಾಚಾರ್ಯರು, ಉಪನ್ಯಾಸಕರು, ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಧನ್ಯವಾದಗಳು. ಮಾನ್ಯ ನ್ಯಾಯಾಧೀಶರು ಹಾಗೂ ನ್ಯಾಯವಾದಿಗಳಿಗೆ, ವಿಶ್ರಾಂತ ರಾಜ್ಯಸಭಾ ಸದಸ್ಯರು ಮತ್ತು ಪ್ರತಿಷ್ಠಾನದ ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರಾದ ಶ್ರೀ ಬಸವರಾಜ್ ಪಾಟೀಲ್ ಸೇಡಂ ರವರು ಮತ್ತು ಎಲ್ಲ ವಿಶ್ವಸ್ತರಿಗೆ ಸ್ವಾಗತ ಮಾಡಿದ ಡಾಕ್ಟರ್ ರೇಣುಕಾ ಗುಬ್ಬೇಡ್ ಅವರಿಗೆ, ತಾಂತ್ರಿಕ ಸಹಾಯ ನೀಡುತ್ತಿರುವ ಸಿಯುಕೆಯ ಸಂಶೋಧನಾ ವಿದ್ಯಾರ್ಥಿಗಳಾದ ಕೃಷ್ಣ ಮತ್ತು ರಾಗಿಣಿ ಮತ್ತು ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನದ ವಿಶ್ವಸ್ತರೆಲ್ಲರಿಗೂ, ಉಪನ್ಯಾಸ ಯಶಸ್ವಿಯಾಗಿ ಪ್ರತ್ಯಕ್ಷ ಪರೋಕ್ಷವಾಗಿ ಸಹಕರಿಸಿದ ಎಲ್ಲರಿಗೂ ಧನ್ಯ.
ಎಸ್ ಸರ್, ಎಲ್ಲರಿಗೂ ಟೆಕ್ನಿಕಲ್ ಪ್ರಾಬ್ಲಮ್ ಇಂದ ಮಾತು ಪೂರ್ತಿ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಿಲ್ಲ ಎಸ್ ಸಿ ಪಾಟೀಲ್ ಅವರಿಗೆ. ಅವ್ರ ವತಿಯಿಂದ, ಎಲ್ಲರ ವತಿಯಿಂದ ತುಂಬಾ ಧನ್ಯವಾದಗಳು ಸರ್. ಬಹಳ ಒಳ್ಳೇದಾಗಿತ್ತು ಇದು ವಿಷಯ ಮತ್ತೆ ಅದರ ಮಂಡನೆ ಎರಡು. ನಾವು ಮುಂದಿನ ಈ ಸರಣಿಯಲ್ಲಿರೋ ಯಾವ ಲೆಕ್ಚರ್ ಇದೆ, ಯಾವಾಗಿದೆ ಅಂತ ಹೇಳಿ ತಮ್ಮನ್ನ ಮತ್ತೆ ತಿಳಿಸ್ತೀವಿ. ಮಹಾದೇವಯ್ಯ ಅವರೇ,
ಮುಗಿಸಿ ಸರ್, ಮುಗಿಸಿ.
ಆಯ್ತು. ಇಲ್ಲೇ ನಾವು ಮುಕ್ತಾಯ ಮಾಡೋಣ. ಮತ್ತೆ ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ.
ಸರ್ ನಮಸ್ಕಾರ, ಧನ್ಯವಾದಗಳು ಸರ್. ಭಟ್ ಸರ್ಗೆ ಮತ್ತು ವಿ.ಸಿ ಅವರಿಗೆ ಧನ್ಯವಾದಗಳು. ಭಾಗವಹಿಸಿದಂತ ಎಲ್ಲರಿಗೂ ಧನ್ಯವಾದಗಳು. ಮುಂದಿನ ಉಪನ್ಯಾಸ ಮಾಲಿಕೆಯ ಮಾಹಿತಿಯನ್ನು ತಮಗೆ ತಲುಪಿಸಲಾಗುತ್ತೆ.